In January of 1973, one of the most controversial and talked about Supreme Court cases, Roe v. Wade, was decided. And very recently in 2022, it was overruled in Dobbs v. Jackson. Let's take a look at the details of both of these cases and how they fit into their time periods. First, the historical context around Roe v. Wade. The civil rights movement of the 1950s and 60s inspired and spurred other rights movements, including the American Indian movement, Latino and migrant workers' rights movement, and the most important for our context, the women's rights movement. Leading up to Roe v. Wade decision, women rights groups had effectively advocated for their causes through books and media, like Friedan's The Feminine Mystique and protest marches. Legal successes followed as the Equal Pay Act of 1963 was passed. The Civil Rights Act of 1964 included a prohibition of discrimination based on sex. And in what would be an important precursor to the Roe v. Wade case, the 1965 Griswold v. Connecticut decision determined that married couples should have access to birth control based on the right to privacy. On the heels of these victories, the women's rights movement continued to gain momentum as they set their aims at the lofty goal of reproductive rights, specifically access to safe and legal abortions, as many states had laws restricting access to abortion or had completely banned it. Women's rights advocates were looking for a legal test case in which they found one involving Norma McCorvey, who would be known under the legal pseudonym Jane Roe, which I will use in this video. Roe lived in Texas and wanted to terminate her pregnancy. However, Texas only allowed termination in cases which the mother's life was at risk. Lawyers for Roe filed a lawsuit against the Texas abortion law in that the law violated Roe's constitutional rights. While the Constitution does not state anything specifically about abortion, Roe's lawyers argued that restrictive laws that limited access to abortion violated other clauses of amendments related to due process and the right to privacy. The Supreme Court released its 7-2 decision in favor of Roe and argued that, quote, this right of privacy, whether it is founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the Ninth Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether to terminate her pregnancy, end quote. The court reasoned that outlawing abortions took away a woman's right to privacy, as having unwanted children, quote, may force upon the woman a distressful life and future, end quote. The court did not open up unrestricted access to abortion, though, as it gave a rather vague direction that the right to an abortion must be balanced with the interests of government, including protecting the life of a fetus and also the health of the mother. States could impose some limits on access to abortions. The majority opinion stated, quote, we need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, in this point in the development of man's knowledge, is not in a position to speculate as to the answer, end quote. This has led to a lot of discussion and debate about when a fetus is viable. At what point does a fetus become alive as a separate living being and therefore having human rights? When it came to the health of the mother, the court established the trimester framework. During the first trimester, it was deemed that abortions were safe for the mother. This meant that states could only impose very minimal requirements and restrictions on abortion during this stage. For example, that the abortion must be performed by a licensed physician. During the second trimester, because of the compelling interests of the health of the mother, states could choose to impose more restrictions. And at the third trimester, the fetus is now fully viable, thereby having rights of personhood, and states have an interest in protecting those rights, making abortions in the third trimester fully or nearly fully restricted. After the ruling, the topic of abortion rights became a mainstay in political debates. Conservative and religious groups protested for Roe to be reversed and abortion to be banned, and supported candidates who had worked towards that aim. The anti-abortion groups labeled themselves as pro-life, and the groups that wanted to keep access abortion legal labeled themselves as pro-choice. Conservative-leaning states were also relentless in passing restrictive laws that limited access to abortion, knowing those laws would be challenged in the courts. The hope was to whittle away at the Roe ruling and eventually overturn it. 49 years later, pro-life groups were able to reach one of their main goals of overturning Roe v. Wade with the Dobbs v. Jackson Women's Health Organization case. Conservative and originalist justices had achieved a majority in the Supreme Court. President Donald Trump was able to nominate 3 Supreme Court judges, which would tip the ideological scales of the court. While many restrictive laws had been passed in states and challenged in the courts, some of which were able to chip away at the Roe ruling, the Supreme Court had been hesitant to fully reopen the Roe v. Wade ruling. A challenge to the 2018 Mississippi state law that banned most abortions after 15 weeks of pregnancy did make its way through the courts and all the way to the Supreme Court. The law also challenged another ruling, Casey v. Planned Parenthood, which had prevented states from banning abortion within 24 weeks. In a 5 to 4 ruling of the Dobbs case, the Supreme Court decided that the right to an abortion was not protected by the Constitution, thereby overturning Roe v. Wade. Justice Alito wrote the majority decision in which he argued, quote, that provisions, the Due Process Clause of the 14th Amendment, has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty, end quote. What Alito means in that quote is that when the 14th Amendment was adopted, most states had banned abortion, and it was not in the intention of the 14th Amendment to establish access to abortion as a right. The Dobbs decision reverted the access to abortion to the states and their individual state laws, of which there is a wide variety. Now, in significant parts of the country, including the very populous state of Texas, abortion is totally illegal. And in a few states shown in light green on the map, abortion is legal at any stage. And all of the states are at various different levels of access to abortion. Finally, the Dobbs decision to overturn Roe v. Wade will not put an end to the controversy over access to abortion. Pro life and pro choice groups are working hard across the country to change individual state laws to either restrict abortion or expand access. If, and more likely when, the court has another ideological shift, the prospect of the court making another ruling on access to abortion is likely.